unabashed,
the most unpredictable,
becomes a headline,
the most volatile,
outrageous behavior,
unsubstantiated narratives, a battle of personalities.
Welcome to Grant Tamasha, a co-production of the Carnegie Endowment for International Peace and the Hindustan Times. I'm your host, Milan. In recent years, there has been a growing concern that the Supreme Court of India, the country's apex constitutional court, is not firing on all cylinders. Critics have argued that the court functions in an opaque manner, exhibits excessive deference to the executive, is far too slow in bringing cases to their logical conclusion, and is hampered by an excessive reliance on a class of elite lawyers who can get their cases heard for the right price. A new book, Court on Trial, a data-driven account of the Supreme Court of India, examines each of these critiques using hard data from the court's own files. One of the book's authors is the constitutional lawyer, Aparna Chandra. Aparna is an associate professor of law at NLS, the National Law School of India, and she has previously worked at the National Judicial Academy in Bhopal and the National Law University in Delhi, where she founded the Center for Constitutional Law, Policy, and Governance. To talk more about the court and some of the findings of her new co-authored book, I am pleased to welcome Aparna to the show for the very first time. Aparna, great to have you, and congrats on the book.
Thank you, Milan. Thank you for having me.
I want to start this conversation off, Aparna, where the book itself starts. You, in the opening page of the book, note that many people have said that the Indian Supreme Court is the most powerful apex court in the world. Yet, at the very same time, qualitative and quantitative data that we have tell us it's an institution in crisis. So we're going to kind of dig into this, obviously, in much more detail further in the conversation. But just tell us at the kind of macro level, what are some of the broad contours of the crisis that the Supreme Court faces?
Right. And really, it's this crisis that's at the heart of the book. Describing this crisis is at the heart of the book. And to put it simply, we argue in the book that the Supreme Court is seeing a mismatch between the role that the court envisages for itself, and that's been envisaged for the court in the Constitution. There's a mismatch between that and the institutional structures and processes of the court, which are now working at cross purposes with its roles. So, for example, we find that this is a court that wants to be an accessible court and provide access to justice, particularly to the most marginalized. And then we find that actually its admission procedures for appeals and its privileging of elite lawyers is hampering its ability to provide access to justice for the most marginalized. We see that one of the main roles that the framers of the Constitution envisaged for the court was that it would hold the state to account for constitutional violations. And we're seeing, on the other hand, that the court has a limited ability to enforce constitutional norms today because constitutional cases are being crowded out because of this appellate function of the court. Similarly, the court thinks the court sets up for itself the ideal of providing timely justice, but the backlog in the court is extensive, and it's as high as that in lower courts. The court says that it's a rule of law court, right, and it's deciding cases on merits of the case on the basis of what the law requires. And we find that its decisions are impacted by extraneous considerations such as the stature of the lawyer or who the Chief Justice decides to allocate the case to, or judges' own interest in seeking post-retirement sinecures, because of which they might decide cases in favor of or against the government. Similarly, so these are the kinds of institutional crises that we are seeing, and we argue that this has to do with the kind of structures and processes that the court has, as much as it might have to do with the norms that the court sets out on the judicial side, or the willingness of judges to say take on the government.
The objective of your book is twofold, because the first objective really is to bring sort of cold, hard, empirical data to bear in an attempt to shine a light on the Supreme Court's functioning. But the second objective, of course, is to use the data and the insights that one can infer from that data to try to inform or to suggest reforms the court could undertake to improve its functioning. I'm struck in reflecting on those two objectives, Aparna, by your observation in the book that despite this well-known crisis, in fact, justices of the court have discussed this crisis in exactly some of the terms that you've mentioned, there's been very little effort to plot a reform process. I remember that, every time we see a new Chief Justice of India take his or her post, they usually give a speech in which they talk about all the things that need to be fixed, and very little gets done. Why do you think that is?
Two or three reasons, I would think. First is, again, structural. Chief justices are, a lot of administrative power of the court is in the hands of chief justices, and chief justices really need to be motivated for any law reform to take place. But chief justices hold office for a very, very short period of time. On average, in the last few years, the Chief Justice of India currently has a tenure of 2 years, and it's by far the longest that we've seen a Chief Justice be in office since 2010. Right, and so on average, a Chief Justice is in office for less than a year. So that's very little time for them to engage in any meaningful reform. The other thing is that, for good reasons to do with judicial independence, uh, law reform and reform at the Supreme Court and at the High Courts has to come from within the judiciary. Judges are, very jealously guard against any kind of intrusion from politicians or from other avenues. Uh, but judges are not necessarily good policymakers, in the sense that a lot of the reform efforts that judges have been championing are based on impressionistic, anecdotal sort of stories of things, very often war stories of this is something that happened to me when I was a lawyer, or this is a case that I saw, so on and so forth. And there's very little hard data, or evidence-based reform that judges have engaged in. And that failure is not just of judges, but that failure is also failure of the part of the profession that I belong to, which is the legal academy, because we really haven't done a good enough job in the past to bring out solid data on the working of the courts, both to do with the fact that getting data on courts is very difficult, but also because we don't. Our legal education in the country is very insular. We don't really engage much with other disciplines, and that means that we don't get the benefit of other disciplines in how we evaluate the working of the court.
I found this anecdote of yours particularly telling. Several years ago, the Supreme Court mandated the creation of a new National Judicial Data Grid meant to track the status of cases at the High Court and District and Subordinate Court level. And it's pretty amazing. If any of our listeners want to, they can go on to this website, National Judicial Data Grid, and basically track cases all around India. But what's interesting is that the Supreme Court itself didn't put its own data on the portal. Is that still the case?
No, as of last month, or maybe 3 weeks ago, they did put up their data on the National Judicial Data Grid as well. It's not as detailed yet as the High Court and the trial court data, but I think they're making incremental improvements there.
Okay, well, that's a good step, and you can count that as an impact of your book. Maybe in fact this is a good place to just kind of pause and ask, which is, this book, as the title suggests, is a data-driven account of the Supreme Court of India, and maybe you could just tell us a little bit about what data you're looking at and where does it come from?
Right. So the core of the book centers around data that we've put together on the court. We did two things. We, along with a bunch of students at the Cornell Law School and at National Law University, Delhi, read all judgments of the Supreme Court for a period of 5 years. That was about 6,000 odd judgments, and we coded them along various parameters, around 66 parameters each. And then that's formed one data set that we've used. The other thing that we did was we scraped the Supreme Court website for metadata on cases. So things like when was it filed, when was it admitted, or whether it was admitted or not, when was it disposed of, is it still pending, what is the subject matter, what is the procedural history, so on and so forth. Who the judges were, etc., etc. And that's about 1 million odd cases. And that's the second data set. We have a few other data sets that we put together on, who've been the judges of the Supreme Court and the High Court and things like that to help us with our analysis. So that's the core of that data set. We had to create these data sets ourselves because it's not really easily available. The court does not really put out data, and the National Judicial Data Grid is an exception, and a very recent one at that. But it doesn't really put out data in a way that is usable, right? Even if it puts out data, it's very aggregate data. So we didn't have official disaggregated data. The other thing that we've relied on in the book is in the last few years in particular, we've had some very good empirical studies on the working of the court by other scholars. So we've built upon that scholarship as well. So that's really the data that's informing our book.
I want to kind of get into the heart of the book and its argument. And one of the things you note at the outset is there is this widespread perception that exists that, look, the Supreme Court of India is a court for the Aam Aadmi, right, for the common man. And that this perception actually is deeply rooted in the text of the Indian Constitution itself. Maybe we could start there. Tell us a little bit about what are the factors that feed into this view that this is indeed a venue that is there to serve, the regular average citizen of the country.
Right. I mean, this is an image that judges have consciously cultivated and courted, and this conscious sort of crafting of image starts towards the end of the 1970s and the early 1980s, because if you remember, till then, particularly during the prime ministership of Indira Gandhi, Indira Gandhi's government was often at loggerheads with the Supreme Court, and her the issue with the Supreme Court was that the court was striking down many of her policies, which she thought were very progressive policies aimed at aimed at the common person, for the benefit of the common person. And so there was an impression that was created, and judges have alluded to this in their judgments, where they said that people think that we are a forum for the legal quibbling of men with long purses, right? The idea that we are really this elite forum for princes and the propertied classes, and not for the common person. And of course, this gets reinforced during the emergency, when the Supreme Court absolutely capitulates to the Indira Gandhi government. So post that, Supreme Court judges very consciously, and they've written about this very expressly. They've written about this in their, extracurricular writing, in the articles that they've written outside of their judgments. Very consciously set out to craft a more people-centric and a more people-oriented image of the court. That this is a more accessible court. This is a court that's there for the common person, and that it has its own basis of legitimacy. It is the people's court. It speaks in the name of the people, and it speaks for the interests of the people, just as the government does, right? And you see, and probably the most famous outshoot of this crafting of image is the public interest litigation movement, which starts at this time, with the idea that if a person or a group of people cannot approach the Supreme Court because they do not have the ability to access the court, someone else can, in public interest, file on their behalf to ensure that their rights are protected, right? And on the on the appellate side, the court does something similar. It says that anyone who has a grievance in any court, from any court in the land, can come to us, and we'll be we'll really look into these matters, and we'll correct errors if we can. The problem with this, of course, is that the court um, does the basic error of confusing access to the Supreme Court and access to justice, right? Because access to the Supreme Court does not amount to access to justice. For the bulk of the population, access to justice means access at the court of first instance, which is their local district court, the trial court. And as the current Chief Justice was saying in some forum a few months ago, that for the bulk of our population, the court of first instance is the court of last resort, because they don't have the ability to appeal upward. However, the way in which the Supreme Court has constructed its own jurisdiction is as if access to justice is to be provided by providing access to the Supreme Court, and yeah, that's the reason why it takes so many cases. That's the reason why it takes so many cases, even though it generally finds that the cases that it has taken were rightly decided by the lower courts on closer examination, and it has a very, very low reversal rate, because its reversal rate is somewhere around 55 odd percent, which means that it's almost a flip of a coin whether the court will reverse the lower court judgment or uphold it. And you would think that if it had a robust filtering process, it would only be taking those cases where there was a strong chance that an error had occurred in the lower courts. That's not the case, and that has to do with the fact that the court wants to be a more open, accessible court and take on as many matters as it can. But that comes at a cost, and that's the cost that we've explored throughout the book.
I mean, one of the most interesting findings in the book is that your data find that the poor and disadvantaged may not be more likely to win in the end, but they are more likely to receive a full hearing for the Supreme Court, right? And so this reinforces the notion of a people's court, that people who bring cases, despite not necessarily coming from, say, elite institutions or what have you, will get a hearing even if they don't win, and that kind of reinforces this. But at the same time, you cite a study of thousands of Supreme Court opinions over many decades, which finds that many, in some years more than half of Supreme Court opinions contain no citation to legal precedent. They are not settling matters of law. And this you use to argue is a way in which the court actually hurts the poor and disadvantaged. And I wonder if you could help us unpack that a little bit. Why is it the case that if the court is not referring to legal precedent or making law, that this is hurting the poor and disadvantaged?
Right. Let's start with the possibly uncontentious proposition that the court has limited amounts of time, and there are only so many cases that it can do justice to in terms of giving it a full and fair hearing. The question is, what cases does the court take then? The Supreme Court has set itself up as an error correction court, right? Anytime I think there's an error, I will correct that error so that that particular case has a proper resolution. And one may say, what's wrong with that? That's a good thing for the court to do, except that the Supreme Court hears a very, very minuscule number of cases as compared to all the judgments that are coming out of the high courts and the trial courts. So the Supreme Court might be better positioned to give us those, to prioritize those cases which require laying down clear guidelines and clear norms on how these lower courts should be deciding cases. What the court is doing instead is seeking to correct error in each individual case. And just because it sees something as an erroneous decision doesn't mean that the decision is necessarily erroneous. It's just that that's that judge's opinion in the Supreme Court. So what we end up with is a system where the court is taking on a lot of cases where there's no new question of law involved, no need to clarify what the law is. The court is only looking at whether this law was properly decided in the facts of the case. And that means that the court is very often not citing any other case. This is a judgment that is never cited again in the future, and that means that it's not adding to that bulk of cases, which is laying down clear guidelines for the lower courts to decide cases. I think the clearest example of this is in bail jurisprudence, right? We've all seen cases where, high profile cases where people have to go all the way to the Supreme Court to get bail. And that's very unique. Very few apex courts in the world are involved in deciding whether a person should be granted bail in the facts of a case without any larger question of law involved. And that's because the court has just consistently refused to put down clear guidelines on when should bail be granted or not granted. And 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 so this taking on this error correction role comes at that cost. It comes at the cost of not having the time to take on these cases where it can lay down clear guidelines that can then guide the lower courts. And I just want to say also it comes at an institutional cost, because it's getting these bulk of cases. Judges are not able to decide those cases. So what has happened over time is that the court has expanded. It started out with 8 judges. It is now at 34 judges. There have been noises made recently that we should further increase the number of judges at the Supreme Court. They don't sit together. Unlike the US Supreme Court, where all the judges sit together, the Indian Supreme Court sits in smaller benches of 2 or 3 judges, mostly 2 judges. Um, they all off deciding their own thing, and very often in diametrically opposite ways, which means that it's adding to the conceptual confusion that we have in the law. Because you have, for any point in law, I can point you to diametrically opposite Supreme Court judgments, which will just add to the conceptual confusion for the judge down the in the high court or in the trial court. So this kind of case by case rescue, right? I'm going to correct the error and do justice in individual cases on the facts of that case, comes with this cost attached, that it's crowding out those cases where a new norm has to be set, and it is adding to conceptual confusion because it's leading to inconsistency in the jurisprudence of the court.
Hey, Grant Tamasha listeners, thanks for listening to the podcast. Putting this show together each week is a labor of love, but it takes a lot of work to put out a great show every week. If you'd like to support the work we do at Grant Tamasha, please visit ceip.org/donate. Don't forget to subscribe to us on Apple Podcasts, Google Podcasts, Spotify, or on your favorite podcasting platform, so you'll be the first to know when a new episode rolls out. Yeah, I'm glad that you mentioned this idea of expanding the number of judges, right? As you mentioned, the court began with 8 justices. It now has 34. And despite that growth, the average time it takes from the date of a decision by the court so lower court to the date of a decision by the Supreme Court is something like 1,542 days you document, which is a pretty shocking figure when you stop and think about it. It seems from your book that this is not really just a question of adding more judges. In fact, there are deeper structural causes which create such inordinate delays. And I'm wondering if you could just help us understand, as you try to pick apart this kind of tangled web that leads to these procedural delays, what is really to blame?
Right. Just looking at that figure once more, this figure of 1,000 odd days is also a figure of the time that it takes for the cases that are disposed to be disposed, right, on average. But there is also this large chunk of cases that are pending and that have been pending in the courts for the really longest time. We're not even accounting for those. In fact, the most delayed cases are arguably the most important cases, because these are the cases where the court has to set up a 7 or a 9 judge bench, which means that really they are the most important cases that are pending in the system. And those are the ones that are the most delayed. Um, so the cost here is incredibly high also for just ensuring that there's enforcement of constitutional norms. With respect to the reasons behind these kinds of delays, there are many. For the longest time, the court also just refused to acknowledge that this was a Supreme Court problem, right? That's why, again, the National Judicial Data Grid didn't have data from the Supreme Court, because delays and arrears were seen as a trial court problem or maybe a high court problem. And our data shows that it's as bad in the Supreme Court as it is in the trial courts and the high courts. The second issue was that very often this was the problem of delay has been seen historically as a problem of resources. Right? There aren't enough judges, they don't have enough clerks, there aren't enough courtrooms, there aren't enough computers, they don't have the latest technology. And you add all of that, and then somehow magically you'll get better judgments. Um, that's not the case. The what we find is that there is apart from there might be legitimate resource constraints, but there's also a cultural problem here. The cultural problem is that the inside the court culture, inside the way the courts work, the litigant is quite marginal to how the court functions. It's a very lawyer centric and a judge centric system, where the lawyer's convenience is privileged, or the judge's convenience is privileged over everything else. And so uh, you have judges who are very happy to grant adjournments. That's something that, and there's sort of an adjournment culture in courts, and it's not just the Supreme Court; it's the high courts and the trial courts as well. It's almost an expectation that adjournments are there for the asking, and so that's definitely one part of it. The other part of it is the resistance that courts have seen, or just the hesitation that the courts have had towards enforcing time limits. There is an understanding again. India's had generally an oral advocacy culture in its courts. And there is this idea that oral advocacy is better than written advocacy, and that at each stage for every matter, lawyers have to be given the time to argue their case in person orally, and given as much time as they need. And that obviously, again, comes at a cost because time is not infinite. Uh, there have been, again, very, very recent attempts in the last year or so at the Supreme Court level for the most important cases, such as constitution bench cases, to enforce some kind of time limits. But this is really for the bulk of the decisions that the court is taking and the bulk of the matters that the court is hearing, there is no such kind of a time limit enforced. So as a result of that, there is it's very easy to get cases delayed and just play that game of delay. Delay benefits the side that has approached the court. It benefits the side that wants to delay legal liability, and it's very easy to play that game in the Supreme Court.
Aparna, I want to ask you about a pretty sensational episode in the Supreme Court's recent history. You talk in detail about the unprecedented press conference held back in 2018 by 4 justices of the court who went public with their concern that the then Chief Justice of India, Deepak Mishra, was misusing his powers as the quote-unquote master of the roster to selectively assign cases to certain judges in a hope that they would produce certain outcomes. I think, people may have heard this term master of the roster before, but maybe you could just help us understand a little bit about the powers the Chief Justice has in formulating benches. What exactly can the Chief Justice do, and what is it that these four justices were so upset about?
So, to answer that question, let me take you back to 1950 when the Supreme Court is set up. It has 8 seats on the court, and someone has to exercise the administrative powers of the court that's given to the Chief Justice. But there's no sense that the Chief Justice has a lot of discretion in how they're exercising those powers. So, for example, there's of these 8 judges, 5 or 6 are sitting to decide constitutional matters. The rest might be sitting in a smaller bench to decide appeals. But because broadly the Chief Justice has to decide who to put on that constitutional bench and who to put on that bench of 5 judges and who to put on the smaller bench, there isn't really that much of a discretion. But as the number of cases increases and as the number of judges increases, what starts happening is that the court starts sitting in smaller and smaller benches and it's hearing more and more cases. As a result, this power that the Chief Justice has of deciding which judge will hear what cases becomes an enormous power. Now, on a regular basis, this power is decided in a very automated way. In fact, the Supreme Court registry has some computer programs which decides this. So, what the Chief Justice will do is the Chief Justice will say that such and such judge will decide criminal matters, or such and such bench of judges will hear all the criminal cases, and the registry will forward all the criminal matters to that bench. That's regular, that's subject matter sort of rostering, and that's fairly routine. But where the Chief Justice's power becomes particularly significant is when a larger bench has to be set up. Because in a particular case, it's found that there are conflicting decisions, or it's a very important constitutional matter which requires setting up a special bench of 5 or more judges. It's called a constitution bench, and in those cases, the Chief Justice has to set up a particular bench, staff that bench with judges, and then post and ask them to hear a specific matter. So the Chief Justice knows what matter they're going to hear, and the Chief Justice has to decide who's going to hear that matter. And it's this power, this master of the roster power of allocating specific cases to benches to hear is the master of the roster power that's become incredibly controversial, because it gives the Chief Justice two specific points of intervening in these very important cases. One is, till the Chief Justice sets up this bench, the matter cannot be heard. And so, for example, the Supreme Court recently concluded hearing the decision, the 370 matter, the abrogation of Article 370. That case was filed in 2019. Within a day or two of the abrogation, but the court heard it only in 2023, 4 years later, because the bench was set up now. Similarly, the court is going to start hearing the court is now heard the electoral bonds matter, even though the case was filed right when the electoral bond scheme was set up, was promulgated. So this is just to say that the Chief Justice gets to decide almost the time at which some of the most crucial questions that are facing the country, facing the polity, are going to be decided, and that can be an incredibly powerful weapon in the arsenal of the Chief Justice. But the other thing that the Chief Justice gets to decide is who will sit on that bench. And what we found in our study, and this is confirmed by other studies as well, is that the Chief Justice does two things, right? One is they disproportionately put themselves on these constitution benches. So in about 88% of all constitution bench matters, you will find the Chief Justice on the bench. Now, this may have been okay if the Chief Justice was, staffing these constitution benches, these large benches, on the basis of seniority. But that's not the case, because the next senior most judge after the Chief Justice is 4 times less likely to be on the bench as compared to the Chief Justice. And there is no seniority norm. Our data shows there is no seniority norm that the Chief Justice is following. There's no other, objectively discoverable norm that the Chief Justice is following, except for one thing. The Chief Justice is almost never in a minority in these decisions. The Chief Justice is almost never dissenting in these cases. In fact, in the history of constitution benches so far, and we are talking about around 2,000 constitution benches since the since 1950. Chief justices have been in dissent only 13 times. Only 13 times in about 2,000 odd cases, when they are on these benches about 88% of the time. No other judge can equal this kind of a record. What does that mean? That the Chief Justice is who is constructing benches, happens to construct benches in a way that they can always carry the majority with them. And that seems to suggest that and that seems to suggest that chief justices are constructing benches in ways that suit their preferences and suit their preferred outcomes.
I just want to ask you, because it's been 5 years since that famous press conference, did it have any long-term impact?
The immediate consequence was, of course, that an impeachment motion was moved in the Rajya Sabha against Chief Justice Deepak Mishra. That didn't go anywhere. But till then, the subject-wise rostering, which judge or which bench is hearing what kinds of subject matters, that was made public. But later that year, two cases go up before the Supreme Court, where folks are asking for some accountability for how the Chief Justice exercises the master of the roster power. And the court absolutely refused to put any constraints or any accountability for how the Chief Justice is to exercise that power. They said that the Chief Justice is a high constitutional functionary, and we should trust the Chief Justice to exercise this power in an appropriate way. And just by way of contrast, last month the Pakistan Supreme Court upheld a law that sought to limit the Chief Justice's master of the roster powers, the power to allocate cases, and created an institutional structure by which these allocation decisions will be made. The Indian Supreme Court has absolutely refused to do that. So in the long term, not really. There hasn't been too much of a movement. In fact, one of the judges in the press conference was Justice Ranjan Gogoi, and he was the next in line to become the Chief Justice. And the expectation was that once he becomes the Chief Justice, things might change. Not only did he not change anything, but as we know very famously, when there was an allegation of sexual harassment against him, he set up and presided himself on a bench that was hearing that matter. So yeah, if anything, things have gotten worse, not better.
And we'll maybe come back to his example when we talk about what happens to judges after retirement, because he was then shortly after retirement given a ticket to stand in the Rajya Sabha representing the ruling party. Before we get to that, let me just ask you about this issue of appointment, because I think it's pretty well known that in India, judges are responsible for appointing other judges. It's a system that the Supreme Court itself has evolved through a body known as the Collegium. You note in the book that, look, neither the executive nor the parliament has much of a role to play. But I wonder whether you would say that that's changing, right? So, I recall a reading work by your fellow legal scholar, Alok Prasanna Kumar, who's shown that, look, the executive is in fact using its powers to shape who does and who doesn't serve on the court by using a pocket veto, by slow walking certain security clearances and security checks and so on and so forth. To what extent do you think that situation has changed? Are we seeing a greater executive imprint on the selection of judges?
Oh, absolutely. So in the last 9 odd years. In fact, beginning in 2014, we've seen a spate of instances where the executive has either returned a recommendation that the collegium has made. Or just sat on a recommendation, right? So exercising almost pocket veto. Um, and while the body of case law through which the court evolved this collegium system had said that the executive could, return recommendation for the collegium's reconsideration if that decision if the collegium reiterates that decision, then the executive is bound to accept it. And we've seen actually quite a few instances where despite the collegium having reiterated a recommendation, the executive has not acted on those recommendations. So it's very much a blatant violation not just of the spirit of judicial independence, but the letter of the law as laid down by the Supreme Court. But then that means that we've ended up in the worst of all worlds, because the big justification for the collegium system is that it secures judicial independence. The collegium system is a very anomalous institution. It's completely insular. It's very opaque. There's no transparency and therefore no accountability for how it is making decisions. Why is it selecting a few judges? Why is it not selecting other judges? So on and so forth, right? So there's been a lot of criticism of the collegium system, and those who support the collegium system agree that there are lots of problems with the collegium system, but the only thing going for it is the fact that it protects judicial independence. And unfortunately, we are now in a situation where even that is not the case, because the executive is interfering quite significantly in judicial appointments through these mechanisms of pocket vetoes, of not of returning recommendations, of sitting on them, so on and so forth. And the Supreme Court is looking into this question on the judicial side, but for the last 2 odd years, the court has been threatening the executive that it will take very strict action against the executive. It's just refused to do that. I mean, it's not really taken any strict measures against the executive. I mean, last year around this time, in this matter that's pending before the court, the Supreme Court had said that we might have to take very strong action against the government if the government doesn't clear these recommendations. And I read last week the same judge in the same matter again threatening the government and saying that we're going to take very strong action against you if you don't follow through. The question to ask is really why is the court allowing this to happen? So yeah, I mean, the executive is interfering. The court can do something about it. It's choosing not to.
You present evidence that justices, particularly as they near the age of retirement, proactively refrain from taking anti-government positions, perhaps in order to ensure that they will be considered for post-retirement jobs, right? And this is especially pronounced in non-election years, because those are moments when justices know pretty well which government is going to be making decisions about their futures. And what I find so interesting about this is that this is not a case where the executive is formally interfering, but rather justices are deciding ex ante to show deference. Is there anything that can be done to remedy this?
I should say that much of this work has actually been done by colleagues in Singapore, Shubhankar Dham, Madhavane, and their co-authors, who have a fantastic paper called Jobs for Justices, and we've relied on their sort of excellent study and data. The uh, the question on what can be done, we have a few suggestions. One is that we need to raise the retirement age for judges from 65 to 70. 65 is as the retirement age places the Indian Supreme Court as an outlier amongst apex courts around the world. It's on the lower end of retirement age for judges. 70 is more at par with where other apex court judges are in terms of retirement. 65 65 was put into the constitution, looking at the the average lifespan of Indians during in the late 1940s, and clearly that's not a parameter that we can use anymore. What a later retirement age might mean, of course, is that then they don't need post-retirement jobs because they have more time to spend in a position of prestige and of value till they are 70. The other policy position that has been frequently advocated, and we agree with, is a cooling off period, a mandatory cooling off period of about 2 years or so, where judges cannot accept post-retirement retirement jobs, to ensure that this kind of an issue where judges know who the government is and what kind of positions are available, and then they pander to that. That's something that can be addressed. And a third element that we put in is in terms of post-retirement benefits, to say that the post-retirement benefits, again, this is a common thing that's done across the world to ensure judicial independence, is to say that the post-retirement benefits would be commensurate with the kind of benefits that one has during their tenure on the court, so that there is lesser need or incentive to seek post-retirement jobs. I will say, though, that all of this only addresses, you know, post-retirement jobs with the government. It does not address a problem that we actually haven't looked at, which is the problem of post-retirement jobs with the private sector. And all that many judges who are not with the government are providing, arbitration services or writing opinions for the private sector.
So, Aparna, I want to ask you one last question, which is a kind of question about the future. Indulge me if you would. Put yourself in the shoes of the current Chief Justice of India. If you could move a small set of concrete reforms that would enhance the performance of the court, not just in the short term, but really in a lasting way, what are some of the, say, top 2 or top 3 agenda items that would be on your list to push for?
Top of the agenda would be to create a permanent constitutional division or a permanent constitutional bench, which can be insulated from the appellate side of the court, so that the court can perform its constitutional function of holding the state to account for constitutional violations. I mean, if there is that is the biggest rationale for the court. That is the biggest role of the court. And if the court's failing to do that, then I think the most important task of reform has to be to secure that role. And I would think that therefore setting up either a permanent constitution bench or a constitution division which has its own staff and has its own there's certain judges that are appointed to that side of the Supreme Court, is something that's doable, that's within the powers of the Chief Justice to do, and that can be done pretty rapidly. The other one, which will require some buy-in from the bar, from the Supreme Court bar, is to put in restrictions on oral advocacy and move to a more documentary practice. This will have multiple. We make the point that this will have multiple benefits for the court. One is that the court can focus its time in court. Judges can focus their time in court in really probing the case rather than hearing the entire case afresh, and they can make better use of their time. It will reduce the influence of elite lawyers who right now depend a lot on their face value, the familiarity that judges have with them, in sort of in securing favorable outcomes for their clients. And of course, that will have an impact, we think, on how long cases take in the court. So if I had to push for two agenda items that were within the control of the Supreme Court, then these would be the ones. Restricting oral advocacy and putting in time limits on oral advocacy, moving to a more documentary practice at the Supreme Court, but first and foremost, creating a permanent constitution bench or constitution division, which is insulated from the appellate practice of the court.
My guest on the show this week is the legal scholar Aparna Chandra. She is an associate professor of law at the National Law School of India. She's also the co-author with Sheetal Kalantri and William Hubbard of Court on Trial, a data-driven account of the Supreme Court of India. Aparna, I just want to congratulate you and your co-authors on what is a really elegant book, which has a ton of data, but yet you don't feel overwhelmed because the way in which you present it is so clear and so measured. It was just really a delight to read it, and I hope that those who can do something about the reform of the Indian judicial system take you up on some of your recommendations. It's been great to talk to you.
Thank you, Milan. Thank you so much for having had me and for those kind words.
Grant Tamasha is a co-production of the Carnegie Endowment for International Peace and the Hindustan Times. This podcast is an HT Smartcast original and is available on htsmartcast.com. You can also find us on Apple Podcasts, Google, Spotify, or wherever you get your podcasts. Don't forget to rate and review. It helps others find the show more easily. For more information about the show and to find the writing we mentioned on this week's episode, visit our website, granttamasha.com. Tim Martin is our audio engineer, and Mira Verghese is our executive producer. Thanks for listening, and see you next week.
This was a Hindustan Times production brought to you by HT Smartcast.
HT Smartcast.